So in a fully integrated legal plan, meaning it covers estate planning, it covers asset protection planning, it covers business planning, it covers tax planning. The pieces we're going to see in a plan like that are things like a revocable living trust and an irrevocable trust and perhaps a limited partnership and certainly limited liability companies, typically more than one, usually a management company. These are the types of entities that one would expect to see in a fully integrated and optimal asset protection plan that also accomplishes all these other objectives. We're also, we are often asked whether or not offshore planning is an important part of an asset protection plan. And whenever we use that word offshore, to some people it carries a negative connotation. And whenever we talk about offshore planning, it's important to understand that we are talking about protecting. We are not talking about tax planning, because offshore planning is tax neutral. There is no tax advantage, there is no tax disadvantage to offshore planning. And so if you think that you're going to do offshore planning in order to save taxes or to hide money, then there's a word for people who do that, and it's called a criminal. So we do not we do not promote or encourage our clients to do offshore planning if that's what their objectives are. So when is offshore planning appropriate? If you have a high degree of liquidity, you have a lot of cash, then offshore planning might make sense. It's fairly expensive and it adds a lot of complexity to your life, but if you have a lot of liquidity, the best way to protect the liquidity is to utilize domestic entities like a limited partnership or a limited liability company in conjunction with an offshore trust in a favorable jurisdiction. And the reason for that is that if things get really, really bad in your life and creditors are coming after you hard, then the liquid part of your estate is offshore and therefore out of reach of the creditors.